They dragged me into court over property I'd legally owned for just 11 days. 11 days. Before I'd even finished settling in, a thick courthouse envelope arrived with my name printed across the front. I actually laughed when I opened it because I was convinced somebody had mixed up the paperwork. They hadn't. The only road leading into their entire subdivision happened to cross land that now belonged to me. Before I get any deeper into this story, I'd like to know where you're watching from. Leave your country in the comments because I always enjoy seeing how far these stories travel. And if you haven't subscribed to the channel yet, now's the perfect time. Hit that subscribe button because what happened next became far more unbelievable than I ever could have expected. My name is Walt Dobbins, and until last spring, I lived a quiet retirement just outside a small foothill town after spending decades working as a county surveyor. For 31 years, I made a living studying deeds, mapping boundary lines, and resolving land disputes between neighbors. So when a 2,500-acre ranch property finally appeared at a probate auction after sitting tied up in legal limbo for more than 10 years, I immediately noticed details everyone else overlooked. Most bidders saw rough brushland weighed down by unpaid taxes. I saw something completely different, a forgotten easement provision hidden inside a 1962 survey that no one had bothered to revise in over 6 decades. I purchased the property outright with cash, no mortgage, no real estate agent, and no unnecessary delays standing between me and the closing. The auction finalized on a Tuesday afternoon. I still remember driving out to the ranch that very day, carrying a thermos filled with coffee while I walked the fence line, convinced I'd finally found the peaceful retirement I'd spent years working toward. What I didn't realize was that instead of buying peace and quiet, I'd unknowingly stepped directly into a full-scale legal battle. Exactly 11 days later, a courier truck rolled into my driveway. The driver checked my address twice before walking up with the envelope, almost as though he couldn't believe he was delivering lawsuit papers to someone who'd barely finished moving in. Inside was a complaint filed by an organization calling itself the Cedar Hollow Estates Homeowners Association. 14 pages of legal arguments accused me of interfering with long-established neighborhood access and demanded a court order forcing me to provide the HOA with a permanent right-of-way across my property forever without receiving a single dollar in compensation. They never even mentioned payment anywhere in the filing. I sat quietly at my kitchen table, read every page once, then read it all again. After that, I couldn't help but laugh because I recognized the exact roadway they were referring to. It wasn't an old shared driveway or some forgotten easement. It was Route 9, the private gravel road running straight through the center of my newly purchased 2,500 acres, the very same road I'd already identified during my title research as the parcel's only lawful point of ingress and egress. They believed they were threatening me, but what they had actually done was reveal the greatest weakness in their own position without realizing it. 2 days later, the HOA president decided to visit me herself. Her name was Marlene Castellan. She stepped out wearing a dark crimson blazer that looked better suited for arguing in a courtroom than standing beside a dusty gravel road. Her sunglasses rested on perfectly styled hair that barely shifted despite the afternoon breeze. She introduced herself with the attitude of someone who seemed to believe she was generously choosing not to have me arrested for standing on land I legally owned. "You need to understand something," she said as she folded her arms across her chest, every word sounding carefully practiced. "Every homeowner in Cedar Hollow has been using that road for the last 15 years. You don't get to take it away simply because you bought a piece of property at an auction." I calmly asked whether she'd ever personally read the recorded easement documents. She answered that her attorney had already taken care of all those details years before. I asked which attorney. She brushed the question aside, saying it didn't matter because the HOA board had unanimously agreed the road belonged to the community in spirit. In spirit. Not according to the deed, not according to any recorded filing, just in spirit. I told her I'd be willing to discuss everything after reviewing the complete collection of documents attached to my deed. She responded with that thin, patronizing smile people wear when they assume a retired man in dusty work boots couldn't possibly understand complicated property records. She had absolutely no idea she was speaking to someone who had spent an entire professional career reading and interpreting. Exit for every single home in her subdivision, and that roadway sat completely within the boundaries of the 2,500 acres I had just purchased. Then chaining that gate shut wasn't merely unauthorized, it was about to become the costliest decision her HOA had ever made. Still, I wasn't about to act on instinct alone. Before making a single move, I wanted absolute proof. The following morning, I drove nearly 2 hours to the county recorder's office and requested every recorded document connected to that property dating all the way back to 1958. What I uncovered genuinely stopped me in my tracks. The 1962 survey I had noticed during my initial title review wasn't simply an outdated easement reference. It turned out to be the original subdivision plat that created Cedar Hollow in the first place. Decades earlier, when the developer divided the ranch into residential lots, he hadn't granted the neighborhood a permanent easement across Route 9 at all. Instead, he issued something very different. It was a revocable license allowing residents to use the road, and that license remained attached to the original parent parcel, the exact same 2,500 acres that now belonged entirely to me. Buried deep inside paragraph 6 was one crucial condition. The license would automatically terminate whenever ownership of the parent parcel changed, unless it was formally renewed and recorded again within 90 days of the transfer. I searched every record available. There wasn't a single renewal, not one. For more than 60 years, no owner, no developer, and no HOA board had ever bothered to renew or re-record that license. That meant the instant my purchase officially closed, Cedar Hollow's only lawful road access disappeared automatically. It had already expired 11 full days before Marlene ever stood at my fence waving lawsuit papers in my direction. She hadn't filed suit against some unsuspecting landowner over a neighborhood road. Without realizing it, she'd sued the one person uniquely qualified to prove that her entire subdivision no longer possessed any legal right to use the only road leading in or out of their homes. The court hearing was scheduled 3 weeks later. Marlene arrived wearing that same dark red blazer, accompanied by 2 members of the HOA board and an attorney whose expression suggested he'd barely had time to read the case before walking into the courtroom. She addressed the judge first. Confident as ever, she repeated her argument that residents had traveled that road for 15 years and portrayed me as an unreasonable newcomer attempting to hold an entire neighborhood hostage. When my turn came, I never raised my voice. I quietly placed the certified 1962 subdivision plat on the table beside the recorded ownership history for the parent parcel. Then I opened the document and slowly read paragraph 6 aloud, giving the judge enough time to follow every sentence carefully. As I read, I watched Marlene's confidence disappear. Her attorney immediately leaned toward her and whispered something with obvious urgency. The judge then asked a simple, direct question. Has the Homeowners Association ever formally renewed this license following any previous transfer of ownership? Silence. Marlene couldn't answer because no such renewal had ever existed. I explained that I hadn't taken away anyone's access. Their legal right to use that road had quietly expired decades before I ever purchased the property. The only reason anyone had noticed was because Marlene chose to lock a gate across the roadway, bringing 60 years of overlooked paperwork directly to the court's attention. The judge denied the HOA's request for an injunction. Instead, he ruled that Cedar Hollow Estates had been relying on an expired license for many years and that any future right to cross my land would have to come through an entirely new easement agreement, one negotiated from the beginning, with fair compensation and only under terms I agreed to. The decision didn't sit well with Marlene's board. Later, while visiting the county offices, I heard that 2 board members resigned within a month of the ruling. The HOA had no choice but to enter private negotiations with me, simply to ensure their own residents could continue driving legally to and from their homes. I never celebrated publicly. There was no reason to. Instead, I mailed Marlene a photocopy of paragraph 6 with the key section highlighted in bright yellow. Attached was a single sticky note that read, "In spirit doesn't appear on the title. Call me when you're ready to discuss real terms." So let me leave you with this question. If you discovered that the road your entire neighborhood relied on had never legally belonged to the community in the first place, would you still have locked the gate before checking the paperwork?